Hello there. This is the Dread Lawyer Neil podcast. I'm your host, Neil Horn. I'm a slightly above average criminal defense and DUI defense attorney in Roanoke, Virginia. This is episode 1 of a podcast series, and I appreciate you being here and welcome. I've entitled this series as Basic Concepts. Over the years, I have encountered basic legal concepts that I have found myself explaining over and over again, and I thought I would present these in an educational format as a basic concept series. This is not legal advice. This is simply educational explanations of basic concepts in the criminal law. And as I've said, the context of these podcasts are going to be the criminal law, either criminal defense or criminal prosecution. I've done both, so I can talk about it both ways. So to get into it, the first topic that I want to talk about in episode 1 is the basic concept of possession of contraband. This is a general concept. More often than not, possession of contraband is possession of illegal drugs or illegal possession of a firearm. There are 3 key concepts. The first is specific. It is the knowing and intentional possession of contraband. This is probably the most important element or elements of the statute or of criminal possession of contraband. The second key concept are the issues of ownership and time. And then the third concept is a broad and practical concept of how possession of contraband is proven. So, the first thing we should go to, you go to the statute. This is Virginia Code Section 182-250. It is the possession of controlled substance statute. This is the statute that makes unlawful the possession of Schedule 1 and Schedule 2 controlled substances. Schedule 1, Schedule 2 controlled substances, for instance, are cocaine or methamphetamine. So for purposes of our conversation here today, we'll simply stick with the felony possession statute. There are other similar statutes for marijuana as well as other substances, but to keep things simple today, we're just going to talk about 182-250. Now, knowing and intentional possession, they cannot be divided. They have to, in order for the Commonwealth to prove the crime of possession of cocaine, for instance, they have to prove that you knowingly and intentionally possessed it. The law requires that to knowingly and intentionally possess a controlled substance means that a person is aware of the presence and character of that substance. Presence and character. Character means it's a mental state. You know what this substance is, and you know it's there. So if you have something and you don't know that it's cocaine, you think it's flour, then you can't be prosecuted for possession of cocaine. If there's possession of cocaine, or you have something that you think's cocaine or that is there that you don't intend to possess or you're not aware of, then you can't be prosecuted for it. It requires both knowledge of the character of the substance and intentional possession of that substance. Now, I'll get to this in a minute, but there are 2 types of possession. There's actual physical possession and constructive possession. Keep those in mind, and we're going to talk about that when we get to the concept of proving the statute. So then there's number 2, which is the issues of ownership and time. Simply put, it doesn't matter if you don't own the contraband, either drugs or a gun. I hear this all the time. Oh, it wasn't mine, it belonged to somebody else. Well, it doesn't matter who it belonged to. If you knowingly possessed it, that's all the statute requires. That's it. As for time, the amount of time you knowingly and intentionally possessed it is immaterial. If you possessed it knowingly, if you possess this contraband knowingly and intentionally for 1 or 2 seconds, that's all the statute requires. So time is immaterial. And I included that in here because people raise that, or excuse me, clients, suspects, they raise that quite often. So just to reiterate, ownership is a factor that can be considered, but it is not dispositive, and time by itself is immaterial. The statute simply requires that the government prove, by proof beyond a reasonable doubt, that you knowingly and intentionally possess the contraband. So moving on to number 3, I am going to illustrate this portion with an actual case. And let me pull that case up. That case is going to be this case, Winfred Hancock versus the Commonwealth of Virginia. This is a Virginia appeals court decision from 1995, and it's numbered 21 Virginia Act 466, and it was decided by the Court of Appeals in Salem on December 29th of 1995. This particular case has to do with the illegal possession of a firearm, and the facts are as follows. A Roanoke City police officer was dispatched to a scene of a suspected shooting from a vehicle. Whoever called the police gave a detailed description of that vehicle that was then relayed to the police officer. Not long after that, the police officer encountered that vehicle that matched the description, and he stopped the vehicle. Inside the vehicle were 5 men, 1 driver, 1 driver's side passenger, and 3 men in the rear passenger compartment. One of those men was Winfred Hancock. Mr. Hancock was seated in the rear passenger seat behind the driver. So, other police officers arrive and they have the men step out. I'm pretty sure that it's not exactly clear in the factual description, but Mr. Hancock was the last to get out of the vehicle. When he was, this is at nighttime, so when he's asked to step out, one of the police officers is shining their flashlight down towards the floorboard behind the driver's seat, and when Mr. Hancock moves his feet, lo and behold, right there just underneath the driver's seat where his feet were was a revolver. The police then recover the revolver. They see that a couple of shells had indeed been shot out of it, and it had a little bit of mud and stuff on it, plus Mr. Hancock's clothing was damp at the time. So it appears there are no statements. There were no furtive movements. In other words, people moving around in the vehicle like they're trying to hide something. There's nothing in the facts that shows that he tried to hide anything. He was just sitting in that seat, and when he got out of the seat, the officer saw a gun. That's it. So he was in proximity of a firearm. And as it turns out, Mr. Hancock is a convicted felon. So he was charged with illegal possession of a firearm as a felon. Now, the case went to trial, and at trial, the trial judge, who was Judge John Apgar, I practiced in front of him both as a prosecutor and as a defense attorney. He's retired now, but he heard the case, and at the end of the case, the defense attorney made a motion to strike and also a motion to dismiss, arguing that the government had not proven by proof beyond a reasonable doubt that Mr. Hancock knowingly and intentionally possessed the firearm. He was simply in proximity of the firearm. Judge Apgar ruled that, in particular, and reading from the case itself, Judge Apgar said that being Mr. Hancock, knew that the gun was there or should have known. Now, I emphasize those 4 words because when the case went to the Virginia Court of Appeals, the Virginia Court of Appeals identified or should have known in its holding where they reversed the conviction. The Court of Appeals was very straightforward and very specifically identified that is not enough to prove knowing and intentional possession. The Commonwealth has to prove, by proof beyond a reasonable doubt, that a defendant knew that they were in possession of contraband, either direct physical possession or constructive possession. Reasonably should have known or should have known doesn't cut it. That's not enough to prove possession of contraband. And that applies not just for, in the context of this case, a firearm, but also in the context of drug possession. And I'll read a little bit more from the drug possession jury instruction. Actual physical possession means that the substance is found on the person. Constructive possession means that the person has dominion and control over the substance or a firearm. And this is important. This is a very important sentence. Mere proximity is not enough. Very simple concept, and it was identified in the Hancock case that I just talked about. He was in proximity of a firearm, and that was all that the government had. So, and as it says in the jury instruction, mere proximity is never enough. It's not enough. That doesn't prove by proof beyond a reasonable doubt. In addition, since we're in this section where we're talking about proving the case, possession need not be exclusive. It could be shared with another, plus the length of time possession is not material, as I already explained. But let me explain the exclusivity of possession. You can have multiple people possess the same contraband if all of them, one, know what it is, and two, intentionally possess it. All right? So you can have, for example, it's two people riding in a car. Both of them are felons. In the center console up front, beside both of them, is a handgun. They get pulled over, handgun is right there. It's not like a drug or anything that you have to go test. It's a gun, and it's open and notoriously sitting there. They both can see it. They're both going to get charged with possession of a firearm as a felon, and the government can prove that. It doesn't matter who owned it. It just matters that both of them are there, both of them know what that is, and they have dominion and control over it. Furthermore, ownership or occupancy of a premises or a vehicle in which a controlled substance or a gun is found does not create a presumption that the owner or occupant either knowingly or intentionally possessed that substance or that piece of contraband. Such ownership or occupancy is a fact which may be considered with other evidence. So that's why I said that ownership is a factor. It can be used, but that by and of itself doesn't create a presumption that somebody knew and intentionally possessed what was found there. That's related to the mere proximity part that I read a few moments ago. Finally, there's two different types of possession. There's actual physical possession where it's found on you, and then there's constructive possession. Constructive possession is proven by circumstantial evidence. Now, people will hear the word circumstantial evidence and think it's not good evidence. Well, that's not right. Circumstantial evidence is perfectly good evidence, and most criminal cases, convictions are gotten off of circumstantial evidence. So what do I mean by these two types? Actual physical possession, as I've already said, it's on your person, okay? Constructive possession, as it says here in the jury instruction, possession may be proven by acts, declarations, or conduct of the defendant, which it may be fairly inferred that he was aware of the presence and character of the substance at the place found. A lot of times you'll run into this when people are trying to dispose of contraband, flush drugs, throw it out the window, such and so forth. that is a very common piece of conduct of the defendant that can be introduced to prove that you knew the nature of what you had and you intentionally possessed it. So constructive possession is the most common, and it can be used to prove, it can be proven by multiple people. Multiple people can constructively possess contraband. So that is where I will leave off. I'll simply reiterate that in order to prove possession of contraband, the government must prove, by proof beyond a reasonable doubt, that a suspect knowingly and intentionally possessed that contraband. And that knowing and intentional possession can be of two types: physical possession, where it's on your person, or constructive possession, where you have dominion and control over that contraband, and it can be proven by other pieces of evidence, circumstantial evidence, that you knew the nature and character of that substance or item and you intentionally possessed it. So that's the basic concept of possession of contraband in the criminal law. I am glad you joined me. I hope this podcast was helpful and educational. I will try to get as much content out at least once a week, put a video onto my podcast channel. I greatly appreciate you being here. If you like what you heard, go down there, smash that like button. If you really liked it, then subscribe or follow my channel, and I greatly appreciate it. Thank you for your time. Take care.